Live Appeals Division 1 is now in session.
Thank you. Please be seated. Counsel, you can remove your mask if you'd like to. You don't have to feel obligated, but feel free to do so. We're here for oral argument in case number 1, CR19-0295, State of Arizona versus Suzanne Jeanette Malloy. A couple of preliminary matters. Counsel, you should feel free to remain seated if you'd like. You can stand up if you want, but you're perfectly fine to remain seated for your arguments. That will mean that you'll have some difficulty seeing the clock if you want to stand up and look at it, or I'll try to remember to give you a heads up on roughly the time you have remaining. Each side will have 20 minutes to present your arguments. Counsel for appellant, if you'll watch the clock, we'll try to help you out. But if you let us know how much time roughly you want to save for rebuttal, I'll try to make sure we do that. Also, please keep in mind we've read the briefs, we've familiar with the record, and so keep that in mind with your comments. With that, Counsel for appellant, you may proceed.
Thank you, judges. Adam Zickerman on behalf of Ms. Malloy regarding this particular case. I would request 5 minutes if I could be noted for rebuttal. This case, sorry, Judge, the microphones are quite loud.
That's fine. You're fine.
In our view, this case boils down to a couple of very simple things. And this all emanates out of Rodriguez versus United States and the length of detention that was held against Ms. Malloy on the side of the road on I-17 on February 18, 2017. That's what this issue is about. Our view is that the officer exceeded scope when, after 12 to 13 minutes had lapsed on the side of the road by our calculation after the warning was given. After that, there was a total of 35 minutes until the dog arrived. There's a total time that exceeded that of what Rodriguez noted by the U.S. Supreme Court. And with that, we believe that the time extended was greater than was reasonably necessary to do the mission as noted in Rodriguez.
Is that the standard? Greater than reasonably necessary?
Judge,
I thought the standard was measurably extend.
it would be measurably extend. Unfortunately, our belief is that it was reasonably necessary to conduct the stop and finish the mission, and the mission here being that of a traffic stop for a person who was traveling 90 miles an hour in a 75.
So you're saying the measurably extend language doesn't apply here?
I think it does, Judge, but I think in looking at it and taking a step into it, you look at from what happened at the time of the stop, the time of the warning, and then how much time elapsed between that warning and when the drug dog got there, including the time in 14 minutes and 30 seconds into that where the officer directed them, don't drive off. Now, the state contends that that was only given to Mr. Shaw, who was the driver. But the problem is, that is the driver. Ms. Malloy isn't going to leave as the passenger of the vehicle. She isn't free to leave. So to answer your question, Judge, to measurably extend and reasonably extend, our contention is that the officer exceeded the scope of the mission of the stop.
Counsel,
Okay.
Let me ask a follow-up question to that. So when Mr. Shaw signed the warning citation back by the trooper's car, at what point did the mission stop?
Our contention is at that point in time when the officer had him come out of the vehicle, and actually just before that told him he was going to give a warning, asked him to step out of the vehicle, come back to his vehicle, because I believe he said he didn't want to hand his computer over. He was concerned. He gave some reasons about handing his computer over, whether it'd be dropped or somebody would take off with it. At the point in time when they were back at the vehicle and he signed the warning, that's when the mission was completed.
Could the officer print out the warning and give it back to Mr. Shaw without measurably extending the stop or not?
In theory, yes. I apologize.
That's okay. So the additional time then to print out the warning and to give the license and registration back, that would not have measurably extended the scope of the mission?
Only in minutes, Judge, but when you look at a grand totality of everything that happened here, if I may, in looking at it, at 5:07 p.m., and I know the court has read these, but I think some of these times are important. At 5:07 p.m., the stop occurs. At 5:17, there was a consent, which is 10 minutes later, there was a consent to search the vehicle asked of the driver, and it was said, no, you have to ask. At 11 minutes past the stop, the consent was then asked, and it was denied. 12 to 13 minutes had elapsed since the stop, and that's when the warning was given. It wasn't until much later, until other things were happening. At that point in time, it is our belief at 5:19, 5:20 by the record, depending on which version of things, whether it was the evidentiary hearing or the trial transcript, that's when the mission ended. Handed the document back, that's when it was done. Plus, when you start looking at 14 minutes into the whole scenario and transaction, if you will, at 5:21, that's when the officer said, don't drive off. Now, I agree and I concede that it was only said to Mr. Shaw, but he was the driver of the vehicle. And it wasn't until 24 minutes later at 5:31 when there was a consent to ask for the canine search. In between the time period is when I think the measurable scope exceeded. And that's the issue that.
Well, there's another time period that I'm concerned with, and I plan to ask both sides about this, but why is the video redacted in terms of audio? Why are we watching blank pictures and not able to hear what anybody's saying?
I wish I had an answer for the court, and I think that's probably best directed at the state since they're the ones who provide that information.
Was there ever any dispute over the redaction below?
I am unaware of, Judge, and I cannot proffer to the court, nor with candor to the court. I don't have that answer.
Fair enough.
Counsel, isn't this situation at least a bit different in that we have, from Rodriguez, that we have two consents. We have consent by the driver. We have an initial denial followed up by a consent to have a dog sniff. Doesn't that make this case really significantly different than what happened in Rodriguez?
I would disagree, Judge, and the reason that it's distinguished is because of the comment by the officer of don't drive away. So I believe that at least
But they had consented.
I understand, but they also have a right to revoke that consent. But when you have other officers who show up at the scene that in a way flank the vehicle around, and there's a show of force that's around the vehicle, a reasonable and prudent person in the same or similar circumstance would not feel free that they could leave, especially when the driver was directed to, quote, don't drive off. I think overall in looking at it, the Fourth Amendment applies. There's an exceeding scope of delay by the officer at that point in time. Judge?
When you're finished, I have a question.
Go ahead, Judge.
All right. Well, there's a theory that hasn't been briefed here that I'd like your response to, and that is the driver of this car could have been charged with criminal speed. And if there was evidence of criminal conduct afoot, why isn't there just probable cause? Why doesn't all this other argument melt away?
Judge, you're right, that wasn't briefed, but in this particular case, I think it would be a standing issue with regards to the two. If that was directed at Mr. Shaw, and let's say in our hypothetical that Mr. Shaw was the one that ended up consenting and finding contraband on, then I would agree that there may be other facts to it with regards to the criminal speed. But in this case, that's not what happened. You had Ms. Malloy, who was a passenger of the vehicle, who...
But it was Ms. Malloy's vehicle that was speeding criminally.
But it was Mr. Shaw who was driving it. And I think that makes a distinguishing factor between it. And if you take a second step to all of this with regards to it, the officer used based off of what he believed as a totality of circumstances. But in looking at it, a nervous behavior of a passenger in and of itself isn't enough. to establish the probable cause, or at least reasonable suspicion that criminal activities afoot.
But you would agree that the Supreme Court, the United States Supreme Court has identified it as a relevant factor.
It is a factor, not the factor, though. And the problem with that, though, judges, is that if you would look at the totality of the factors that were given for the reasonable suspicion that was here, one of them was that the vehicle, and during this time, they did this border check to see whether or not the vehicle had crossed the border. And they found that the vehicle had crossed the border within the month, and there wasn't a lien on the vehicle, and that gave suspicion. And I frankly, when I read that, I was concerned because I have a vehicle that's free and clear. I travel across the border to go to Rocky Point. That's not criminal in and of itself. And the state concedes that both of those are minimum weight in their response, but it's still, that's what the officer was looking at. In totality of those, I don't think the officer truly had reasonable suspicion that Miss Malloy was committing the offense. I agree, Judge, that if this was directed at Mr. Shaw with the driving behavior going 90 miles an hour in a 75 and other factors to it, I could agree that there would be a different analysis. But this is a passenger of the vehicle. And that's our contention through all of this, Judge, is that because of this, the state exceeded the scope, they exceeded the time, they gave a directive, there was a seizure under the Fourth Amendment by him saying, don't drive off, even if it was owing to the driver, because that person is dominion control over the vehicle, as the one driving, and there wasn't reasonable suspicion to be able to do what the officer did.
Counsel, can I ask a follow-up question to the statement, don't leave, or something to that effect? Wasn't that given by the trooper to Mr. Shaw before the warning citation and the registration and the license were returned? Wasn't that statement made, don't leave because I still have your documents, but then within a short time after that, weren't the documents returned?
Judge, when I went through the records myself, reading both the motion to suppress, the response to that, looking at the transcripts of the evidentiary hearing, et cetera, my timeline became a little bit different than that of what the court just posed. My timeline was that at about 5:19, 5:20, the warning was given. At 5:21, that was the officer making the statement. So I have them in reverse of what the court just gave.
But the body cam footage would show that. If I went back and watched it again,
I
that's where you're getting that from.
I think that would be the best evidence with regards to that. And I ended up, with candor to the court, ended up getting some of the notes from the trial counsel in this with regards to how they broke it down as well. And some of the times that they had were a little bit different than what the officer had, which was a little bit different than what the evidentiary hearing showed as well. So I think some of the numbers are off or skewed a little bit, but our contention is that with regards, the warning was given, then the directive, and then the request for search of the vehicle, dog sniff, via dog sniff.
And when relative to the request for consent for the dog sniff was the license returned to Mr. Shaw?
My understanding, Judge, is when the warning was given, warning was returned, et cetera. There's statements that also part in there, don't drive off, according to the state, where don't drive off, I have your license, et cetera. But our contention on that is that happened at about according to even the state's notes, was between 14 minutes, 10 seconds, 14 minutes, 30 seconds into the stop, which would timeline about 5:20 5:20 p.m. in the line of things, which would kind of coincide with the order in which I've been giving the court. So that's our contentions, Judge. And I think that's, in this particular case, with regards to the suppression motion, it should have been granted. There was an abuse of discretion with regards to that, because we contend that the court did not adhere to what we believe is the controlling law of Rodriguez.
You have 7 minutes left.
I'll reserve that. I think it's a good breaking point. Thank you, Judge, for letting me know.
Good afternoon, Assistant Attorney General Michael O'Toole on behalf of the state. To answer Judge Schwann's two questions, first regarding the video, it was not addressed during an evidentiary hearing, and I have no knowledge why that was turned off.
If we were to request that you supply us with a full video, would you be able to do so?
I could ask certainly, but I think it is the full video. I think what happened is that he turned the body cam off because he had a civilian and a ride-along passenger, so he wanted to talk to him, so.
Oh, yeah, I think we'd all like to hear what he said, too.
Right, but I think he turned it off, so it's not recorded. I'm not
Would you
positive.
do us the courtesy of investigating that?
I will do that.
Thank you.
Regarding your second question, that was not addressed, whether or not this was criminal speed and whether he could have been arrested, that was not addressed in the trial court. But frankly, I don't know if that gets us over the hump anyway, because in the old days, under Belton, you could basically search a car after arrest, but after Belton, was it Davis, or Gant, I'm sorry, from Arizona case, you can't do that automatically. So we wouldn't have the drugs automatically as a result of a search of the vehicle. But this case is a lot different from Rodriguez. In Rodriguez, they addressed the question of whether or not you can extend a motor vehicle stop once completed to conduct a dog sniff if it's de minimis of just a few minutes, and the court said no. It was not addressed here. In Rodriguez, the dissent basically talks about the fact that there was reasonable suspicion, which kind of moots the whole issue. The majority didn't reach that issue, but the state believes in this case that resolves the issue because there was reasonable suspicion by the time the mission of the stop was over. And I agree with the opposing counsel, the mission of the stop was completed when he basically had him sign the waiver at the back of
So
the
the
car.
consent was unnecessary. They could have simply detained both individuals and searched the vehicle because there was...
They had reasonable suspicion to run a dog around the car, to detain the car for...
But what about to detain the car for as long as it took to get a dog?
Well, a reasonable period of time at least.
And the reasonable suspicion you're saying is just based on this profiling evidence?
Well, it's based on several things. First of all, when approaching the vehicle and asking the driver where he's coming, it's casual conversation, where you guys coming from? He said, and he didn't know where he was coming from. That was very unusual. The passenger, Miss Malloy.
He said,
He said, He put his hand to his face.
Surely we can't issue a decision, the Arizona courts, that says is probable cause.
Well, in this context, is basically an indication this driver couldn't answer a simple question directed by the officer. It's not the sole factor, certainly, Your Honor. I'm just starting out here.
Okay, I'll give you a running start, but so far I'm not getting airborne.
Okay, that's a very small factor, very small factor. The biggest factor, the bigger factor, is Miss Malloy herself. She is shaking, visibly shaking. The officer testifies to that. I'm not sure it's immediately visible on the videos. I watched it a few times, and the more I'm concentrated, I do see her being very unsure. But the real thing, though, is that her boyfriend says to her, "Relax, he's not going to shoot you." So the boyfriend, who knows her, is basically seeing such nervousness, such fear from her, that he compares it to being shot.
Have you ever been the subject of a traffic stop?
Yeah.
Was it a calm experience for you? Because I know I'm nervous every time I get stopped.
Well, I wasn't shaking. It was fine, I think. I don't know. But
I'm impressed. It makes me nervous to get pulled over by the police. And I dare say if you poll the population, you'll find a majority of people are nervous at that moment.
Well, again, this is not just being nervous. This is her being so nervous that someone she knows is basically commenting to her, "Please calm down. You're acting like he's going to shoot you or something," which is unwarranted by the circumstances. It's daylight. This officer, if you listen to the video or watch the video, he's extremely friendly. He's very casual. And then he kind of just, the whole time he was very casual. She's a passenger. The vehicle is licensed, it's insured, it's registered. There's no problem with the vehicle. Why is this woman why is she freaking out so much? And to the point where her boyfriend again says, "Calm down, you're scaring me." These exaggerated attempts at humor just show how extremely nervous she is. And I think in this context, it's kind of akin to what we have in the Warlaw case, where it's a headlong flight, extreme reaction to the police presence. And that's not all we have.
I don't think it's possible to characterize her reaction here as extreme. You might be able to get away with nervous, especially given the boyfriend's statements, but extreme? I've watched this video 4 times. There's nothing extreme about her reaction.
Well,
she's friendly. She's practically flirting with the officer.
I certainly don't see it that way. And the officer who was there, I don't think we pick up everything quite, the video is pretty good quality, but I don't think we pick up everything the officer who was there saw. And again, I think the boyfriend's comments speaks volumes. And then we go on to the checks. I agree that the fact that there's a lien is recently registered is not a huge factor, but under United States versus Avizu, we basically defer to the officer's training experience. And his training experience, which was not questioned here, and this was not questioned as a valid fact that he learned during his training, that this is possibly an indication of drug trafficking. And then we have the fact that the car crossed the border a couple of times, once in the last month. But really, what we're getting to in a little bit, though, when we have the stories coming up, he basically, the initial story, too, he's basically going to Arkansas, which he didn't remember initially, to look at a car, a 38 vehicle, I guess, under the, supposition that if he likes it, he's going to drive that back across country, and she's going to drive her car back. That seems a very unusual kind of thing to do at first glance. And then when you start talking to them individually, which you're allowed to do under Rodriguez, they did that in Rodriguez, and there was no question that was fine. You have these different stories coming up. She talks about him going to see it with a friend. He denies it was a friend. They both initially said it was a 38 coupe. And you're only going to go out and buy a car, a 1930 vehicle, if you're a car guy. And if this guy is mixing up a 38 and a 32, that just doesn't seem plausible. So at this point, between everything he's got here, he has reasonable suspicion. And you're looking askance at me, but we have to look at these things completely.
I guess I'm looking at, I'm just imagining how this theory plays out. I mean, it would really, if you follow this argument to its logical conclusion, the postulate of the argument has to be that citizens are under an obligation to communicate openly and candidly with the police, and they are not.
Well, they don't have to communicate if they don't want to. But
if they didn't communicate, my God, I mean, what would the officer's training and experience have told them then?
Well, we don't know. It didn't happen here. I guess he would say, well, they weren't communicative, and I didn't.
And that's a sign that there's hiding something, right?
I don't think that would be a viable basis for a stop, no.
But is? I mean, if we're going to say that saying actually is relevant to a Fourth Amendment analysis, then we have to acknowledge that refusal to communicate would also raise suspicions.
It possibly could in some circumstances.
If you refuse to communicate with me right now, I'd be suspicious, and probably vice versa. If people are free to go about their business unless the police have reasonable suspicion to stop them, then the reasonable suspicion either has to arise from external circumstances, or we have to presume that people are under some sort of an obligation to communicate openly, candidly, honestly, and smoothly with the police. I have trouble finding support for that.
Well, the case law is, as cited in the brief, indicates that inconsistent travel plans and nervous behavior are two very important factors for reasonable suspicion.
Counsel, on reasonable suspicion, if I understand the trial court's minute entry correctly, the court did not address whether there was reasonable suspicion. What is the state's position on that? Should this court be remanding for this trial court to make that call in the first instance?
The court could certainly do that. I think the trial court made a mistake, and when I think it basically didn't realize that when he signed the warning that he didn't give the information back. But he didn't give the information back until shortly after he got consent from Ms. Malloy. So that was a factual error by the trial court. But I don't think the facts here are really at issue. No one challenged, for example, the officer's credibility, and we do have the videotape. So I think it's frankly permissible either for this court to resolve the issue or remand it.
Okay, fair point.
Counsel, question. Let's just say, for sake of argument, there was not reasonable suspicion. Let's just say there wasn't. Between the time that consent was given and the warning citation was signed, first the warning citation signed, then consent given, was the traffic stop impermissibly extended?
Yeah, I don't think so. We have, at this point, the mission of the stop is over. He speaks briefly with both of them, and, the fact that they don't have their information to actually leave is not inconsistent with voluntary consent. For example, we have the Bostic case where they're on a bus and people really don't feel they're free to leave the bus, but they nonetheless have the authority to, deny consent. So here, the consent appears to be independent of everything else.
We have a legal fiction, of course, about people feeling free to leave, and I understand that's part of the law, but at some point that fiction really bleeds into fantasy. If you're holding someone's driver's license, you've asked them for consent to search the car and they've said no, how much more can you do?
Well, they both felt obviously free to say no because they did initially, and Miss Malloy didn't seem to have any problem saying no to the request for consent, and then she seemed perfectly fine with the request to run the dog around the vehicle.
Of course, that request was given in the absence of the information that there was no dog available at that time. But what do you make of the fact that after Mr. Shaw gives consent to search his belongings, the officer doesn't do it? There's all this downtime. The interest in Mr. Shaw's belongings seems quite attenuated.
Well, there was some downtime, but in fact, shortly after, I think it's about a minute after Ms. Malloy gives consent, the information, the licenses and the paperwork is given to the Ms. Shaw or Mr. Shaw and Ms. Malloy. At that point, theoretically, they could have nothing prevented them from saying, "Hey, we thought the dog was right here. We'd like to be on our way," or anything like that.
Except the officer saying, "Don't drive off."
But that's when before he gave them he says, "I have your information here. Don't drive off without it." Right. So then he gives it back to them a minute later after he gets the consent to run the dog around.
So we should therefore assume that if they had just decided, we're late for dinner, we've got to go, and they had started the car and driven off while the officer is waiting for the dog, everything would have been fine. They wouldn't have been pursued. No hard feelings.
Well, that would be a different case, and then it would rise solely on the reasonable suspicion at that point.
So they weren't really free to leave. Because you're saying there was reasonable suspicion. So the officer easily could have detained them again.
Well, we don't know what would have happened. We know, I think, objectively there was reasonable suspicion, but no one asked him, what if they, in fact, indicated to you they didn't want to consent? That question was not asked, and he didn't say, well, I would have definitely detained them. He has discretion, even though he has reasonable suspicion. He may not, go
He's
ahead.
called for a dog, and he's just going to let them drive off and say, never mind the dog, they drove away.
Possibly, we don't know if that's not this
No,
case.
but if you're there in the moment, which we have to examine for purposes of this analysis, if you're there in the moment, do you think that a reasonable person would feel free to drive off in those circumstances?
Well, not without their information, certainly, but when the information is given back, and I think under the case law, that their consent is voluntary, and under a reasonable person standard, yes.
Counsel, you have 6 minutes left about. Can I ask you a question about going back to Rodriguez? Where do you think Rodriguez meant to lay down a bright line rule about getting the signature on the warning certificate? Is that a bright line rule that basically that's when it stops? That's when the mission stops, and that there needs to be something new to basically trigger any right of the officer to keep the investigation going. Would you agree with that, or is there not? Am I reading too much into Rodriguez?
Well, yeah, when the mission stops, and Rodriguez had a case where the mission was completed and there was no consent because unlike here, the defendant refused consent. So at that point, you don't, that's clear, despite prior case law by some courts to the contrary, you just can't say, okay, we're just going to hold off a little bit and basically get the dog here.
But once the ink is on the warning or the citation, does the officer need to just zip it and get back in his car and head down the road? Or can the officer say, hey, can I ask you one more question? Just, just wondering where you guys are headed right now, or I don't know, just some
Yeah.
follow-up question. Is that
Right, so
permissible?
assuming everything is handed back to the driver and the mission's complete, at that point, as case law indicates, Arizona case law included, that can become consensual, and that's depending on the circumstances. And if you would say, hey, you're free to go, but would you mind if I ask you a couple questions? And at that point, they say yes, that would be consensual, for example. But I think in that situation, you'd have to have the clear break. Here, it's kind of complicated because we have the mission being completed generally by the fact he's citing the warning, and then the fact that, he didn't actually print it off for him until asking
At
for
least a
consent.
couple of minutes later, or some, I don't know the exact time frame. Okay, thank you.
Unless there's further questions, the state would.
I don't want to overstate your position, so I don't ask this question as a challenge, really, but it does seem to me that you're arguing that if a citizen is nervous enough or shifty enough, their Fourth Amendment rights diminish. Is that what we can distill this argument to?
I'm arguing consistent with established Supreme Court precedent that nervousness is a factor in determining whether it's reasonable suspicion. And again, it's suspicion, not probable cause, it's suspicion. And United States versus adversary tells us we can't divide and conquer. We can't say, oh, that is not enough. We can't say, oh, that inconsistent story is not enough. But here we have extreme nervousness. We have two really dramatically different stories. Why are they lying about this? I mean, they're not being consistent. She's being very vague. He can't get the car right. I mean, I used to have
Why does the state have a right to know? Why does the state have a right to the truth from somebody just passing down the road?
Well, because under established Supreme Court precedent, including Rodriguez, the officer has the right to ask people about their travel plans. It's partly.
I have no problem with the question. I guess I have a problem with what you're making of the answer. I understand that nervousness can be a factor in many totality of the circumstances analysis, but here that's basically all you've got. They were nervous and they were shifty, therefore we can search them. That's a very slippery slope. I'm not sure I'd be comfortable getting on.
They were nervous. He couldn't even name where he coming from. The girlfriend, Miss Malloy, was so nervous. Her boyfriend said, he's not going to shoot you. Calm down. Even though she's a passenger, she had nothing to worry about if she had nothing in the vehicle. And they have these completely inconsistent stories, or very inconsistent stories, where they're talking about different model vehicles. And I can't imagine someone, I had a 1970 Cougar, and I would never confuse that with a 68 or something. An older car has a special meaning, especially
351 two-barrel?
No. But that, to me, is a very big factor. The fact that she said that he went to look at the vehicle with a friend, the fact that he has said he had no friends down there. So based on all the totality of the circumstances listed in my brief, consistent with United States versus Arvizu, it's reasonable suspicion, which is far less than probable cause. And that's all it was, reasonable suspicion to detain him a little bit, to ask for the consent, which was
I guess I'm agreeing with you. I agree that they were nervous and they were shifty. And I'm asking whether you're comfortable living in a world where that's enough under the Fourth Amendment.
I'm comfortable relying on the cases that hold that is enough. And if you look at Arvizu itself, from the United States Supreme Court, you have a situation where basically it's mechanical waving of the children that basically gets the cop's attention. He finds it very suspicious, and the fact that driving on a road that's not very well traveled. It's really not that much in Arvizu, and again, it's reasonable suspicion. They talk about how low the standard is. They talk about the fact that you can't take each individual factor and you divide and conquer and say, that's not enough, that's not enough, that's not enough, that's enough.
So,
we look at it all together.
So are we relying then in this case on reasonable suspicion, or are we relying on consent?
The state's primary argument is reasonable suspicion by the time they were asked for consent, so there's no Rodriguez violation.
So in other words, we could dispense with the consent, and he could just say, based on how nervous and shifty you are, I require you to stay here until I get a dog.
Well, I don't want to decide cases that, this case, they did consent, so we don't know for sure if the officer would have done it, but we know based on this record and the facts that he could have.
If you're going to win this case, we have to write a decision.
Right.
And do we base that decision on consent, or do we base it on reasonable suspicion? Because if we base it on reasonable suspicion, it just writes very differently.
Well, I think the easiest way to go is reasonable suspicion.
Okay.
Thank you, counsel. Your time is now up. Thank you.
Thank you, Judge. With regards to reasonable suspicion, if the court is going to base this on it, we need to look at the totality of everything. And I think, Judge, you've hit the nail right on the head. Are we going to base a Fourth Amendment analysis on the words and now somebody's Fourth Amendment is on a slippery slope?
Counsel, don't most drivers know where they're coming from?
Maybe, but in the facts of this case, if I recall correctly, they were coming from Arkansas to Phoenix, and we're going to spend, or had spent, or going to spend 2 to 3 days and try to look at a vehicle. It was a 1938 or 32 on a slip of the tongue. But does that in and of itself establish?
No, none of the factors in and of themselves. I mean, that's the point. It's a totality of the circumstances. What about the fact that how often do you go somewhere and stay for a couple of days and you can't remember the hotel that you stayed in?
Well, Judge, actually, I can tell you that, my wife and I did a trip in Colorado. We went all around from Flagstaff.
I'm talking one place. They went to one place. And it was, I think that most of the time, most people can remember the hotel that they stayed in.
Well, in my reading of it, the recollection, I think it was like a Super 8 or something like that. If it's not a memorable experience, sorry, that's a terrible word for me, experience, sometimes you don't remember. Maybe if a person is driving, and if you've ever done a cross-country trip, driving across country, especially from Arkansas, and I've done it from New Hampshire to Tucson, you drive in long hours, you get a little punchy, and you may not necessarily remember each and every place that you stayed along the way. I can remember once sleeping in the back of a truck. Does that make it reasonable suspicion that I couldn't tell you what state it was, but I remember sleeping there? That doesn't in and of itself establish reasonable suspicion. And I think that looking at a totality of this, as the court is noting, you're looking at the word and somebody who's shaking. And I agree with you, Judge, with regards to if we're going to base a Fourth Amendment analysis and a reasonable suspicion on somebody saying the word and being nervous, I can attest the court, and as the judge said, if you get pulled over, you're nervous. Whether you're the driver or the passenger, you're nervous because you don't know what's going on.
True, but I would venture to say most of the nervousness, Fourth Amendment cases, which are many, thousands, I'm sure, most of them involve the driver. A good majority, at least, involve the driver. Doesn't the driver have a lot more reason to be nervous? Why does a passenger need to be nervous?
Speculative all around. I guess we could have an hypothesis.
The fact that they're carrying drugs would have nothing to do with it.
Well, Judge, I'm not going to admit or deny that with regards to that, but there is and can be other reasons why a passenger of a vehicle is more nervous than the driver. Maybe the driver's better suited for under certain stressful situations. Maybe the passengers had bad experiences with law enforcement, and when they see law enforcement, they start getting more nervous because of that past experience. I can tell you, if you get pulled over, and maybe you're lucky enough you haven't been, but if you got pulled over and got a ticket, you remember that area, and for some reason, especially even today, driving down from Flagstaff, I-17, I can tell you the spots near Camp Verde, near Sunset Point, that usually they're sitting in the median. You remember those particular things, and that memory translates into when an officer and you are having interaction, whether you're the driver or the passenger. So I think if you're looking at a reasonable suspicion analysis in this particular case, the state, as they said, it was an objective. I disagree. It was not an objective view. This was a subjective view of an officer who looked at a couple of things: no lien on the vehicle, across the border.
But our view is objective.
Absolutely, Judge.
Correct.
And review of it is certainly an objective. What would a reasonable and prudent person, in this case, the reasonable and prudent court, look at? But when you're looking at from that officer's perspective, at that point in time, to establish totality of circumstances, because it's supposed to be established at the time. You can't complete the whole case and then say, oh, I had it in hindsight. That's not the way we work. We look at that point in time. How are we there? And what we had was somebody who is a passenger who was extremely nervous. We had somebody who had crossed within the last month, crossed the border, and had no lien on a vehicle. and traveled across country to look at a 1938 or 32 Ford Coupe. Those are the factors. And if that's the standard, then I think it's incredibly slippery slope of how fast the Fourth Amendment gets eroded. And that's the problem here. We don't need to erode it. We need to uphold it. And based off of all the stuff in our pleadings, the case law, and especially Rodriguez with the timeline thereafter, even if the court says we're not going to look at reasonable suspicion, we're going to look at the consent part, let's look at the timeline of all this. There was exceeding amount of time from the time the warning was issued, signed, until the drug dog showed up, until there was consent. It exceeded the scope of that of Rodriguez, and that is our contention throughout all of this. And I think
You have a minute left, but
I have, unless the court has further questions.
I don't have questions, except I would like to clarify how long the state thinks it needs to investigate the issue of the redactions.
I have a note to call the prosecutor right away when I get
Okay,
back.
can you get us something by next week?
Oh, sure.
Up or down, whatever it shows. Thank you.
Judge, if the court would like to, I'm welcome to contact, I think it was Ms. Harris, who is the assigned prosecutor in the case.
Let me just ask a follow-up question on that. The copy that we have is the copy that the trial court had, correct?
Correct.
Okay, thank you both.
If there are objections to our considering an unredacted version, we'll be happy to entertain them in connection with the filing that attaches the new disk, if a new disk is available.
Okay, again, I don't think it's redacted. I think he just turned it off, but we'll find out.
Thanks.
Okay, thank you both for your arguments in this interesting case this afternoon. The court will take this matter under advisement and issue a decision in due course. The court is adjourned.